All right. Good afternoon, everyone. Welcome to the Fair Housing Center of West Michigan's training on fair housing rights of families with children. My name is Brianna Miranda, and I'm one of two education and outreach coordinators. And joined with me today is Liz Keegan, our Director of Education and Outreach. um, sorry, it's really challenging to navigate this. Okay, there we go. So just some housekeeping things before we begin. Everyone is muted and your cameras are off, so we cannot see or hear you because this is a webinar. It is being recorded, and we will provide the link to everyone after it has been uploaded. Please use the Q&A to send any clarifying questions during the training. We'll also have time at the end for some more detailed questions. If you put them in the chat, they may get lost. So please use that Q&A feature. It should be on the bar on the bottom. It says Q&A. Evaluations will come up automatically in your browser. Please utilize those. And if you would like a certificate, there is the option to request one in there. We can begin today and talking about some fair housing rights. Like I said, I'm Brianna Miranda, and I'm here with Liz, and this training is in support from the Michigan State Housing Development Authority, or MSHDA. So we will talk about some fair housing laws today. We will cover familial status and within that occupancy standards, advertising applications, policies, and differences in treatment. And then we'll talk about how to report discrimination, and then our resources that we have that can be provided and helpful in answering any other questions. So we're going to start off this morning, afternoon, and getting everyone thinking. We'll do a true and false here. So a property manager has the right to inquire about whether opposite sex children under the age of 18 will have separate bedrooms. True or false? And we are asking this question because we actually get questions about this question often. So it's a good one. Give about another 30 seconds here for people to get those answers in. And if you're joining us as a group, you'll have to collaborate and decide on one answer. All right. A couple more people answering. All right, I'm gonna close that poll. So there was a majority, however, it was pretty close. So this is one of the reasons we're bringing up this question, is because this is a common misconception. So it is false. A property manager does not have the right to inquire whether or not children of the opposite sex under the age of 18 will have separate bedrooms. We do hear that a lot, and we do hear that it is law in Michigan. However, there is no law in Michigan that says that children of opposite genders and sex have to have separate bedrooms. So that is just something to be thinking about as you hear about housing that is being provided to families you serve, or if you are a housing provider, any rules or policies you may have.
We are busting myths this morning.
Right off the bat.
Yeah, we'll start with one of the most common questions.
All right. And then if you are not familiar with who we are, our mission is to really prevent and eliminate discrimination, promote inclusive communities, and ensure equal housing opportunity. We do this through various ways. As right now, we are providing education, and we also do outreach. So if you are part of any agencies and you would like information from us, outreach materials, or you have events coming up, tabling events, we are happy to join those events as we have staff capacity to do so. And then we also have an enforcement side, and an advocacy side in which we help clients if they're facing discrimination, and help advocate for them or provide enforcement where necessary. We were founded in 1980. It was a grassroots effort, sorry, words. And it came from both the housing industry and community organizations coming together and seeing an issue within their neighborhoods and creating the Fair Housing Center of West Michigan to help try to desegregate schools and integrate neighborhoods. We cannot provide legal advice. We have no attorneys on staff, so this presentation is for educational purposes only. And one thing we just really want people to be thinking about as you think about fair housing is just where you live affects how you live. So having choice is just really, really important in that it affects all aspects of your life. Your access to healthcare, education, transportation, economic growth, things like that. So just be thinking of that. That's just something, overarching theme that we like to kind of think about when we're thinking about fair housing. There are other fair housing centers in the state. The presentation handouts that you received, and if you did not receive them, please let us know in the chat. Our other education outreach coordinator, Lindsay, is monitoring that and can provide those handouts to folks if you just send your email and let us know that you didn't get it or would like another copy. So these are listed there and you can click on those different centers. And then this is kind of the map in which we are broken down. We are the purple area, and the other fair housing centers serve the other areas of the state. However, if you do contact us and we're not in your service area, we will provide you the referral to the other agencies. So no worries if you call us on accident. So what is fair housing? Fair housing is the right for individuals to choose housing free from discrimination based on what we call protected classes. And these are within federal, state, and local laws. So these are defined through those local laws. Federally, we have race, color, national origin, so where somebody is from, sex, which includes sexual orientation, gender identity, and being transgender, religion, disability status, both mental and physical disabilities, familial status, which we'll be highlighting today. That is the presence of children under the age of 18, which we'll go into a little bit more of that definition later in the training. Additionally, there is the HUD equal access rule, which if you receive HUD funding, that these are additional protected classes that fall within your purview. At the state level, so if you are located in Michigan, I believe everyone registered is in Michigan. These are additional to the federal protected classes. So marital status, whether or not you are married, single, widowed, divorced, that should not affect your choice in housing. Age, so if you're 18 or older, are able to enter into a legal contract, you cannot be discriminated against other than 62 and older housing and 55 and older housing. Those are exempt because that is for seniors. And then additionally, new protected classes that went into effect at the beginning of this year, sexual orientation, gender identity, and gender expression. And then additionally, there, of course, are local protections to add on to that. So it's important to check with your local city, township, village, and make sure that there are no additional protected classes. I know in the city of Grand Rapids, we have height and weight, source of income, and that's kind of around our service area. Those are some common ones we see. So just make sure that you understand what protected classes are covered within the location that you are in. We wanted to quickly highlight what the equal access rule is. These are HUD-funded programs, and they cannot discriminate based on the composition of the family. So theirs is a little bit more broader. It's adults and children, or just adults. They also, if you have HUD funding, age is not, you cannot discriminate on age, disability status, marital status, sexual orientation, or gender identity. The 2016 Equal Access Rule does address people that are transgender and gender nonconforming. So those are some things just to be aware of. If you do receive HUD funding, these are also applied to you. Additionally, VAWA, or Violence Against Women Act, that helps folks that are provides housing protections for people applying for or living in subsidized units who've experienced domestic violence, dating, violence, sexual assault, or stalking. So these are just things to be aware of in addition to the protected classes when it comes to other laws that may apply. So
Well,
what type of, oh, go ahead.
I did just want to make sure that some cases can be brought under fair housing laws in private housing related to domestic violence if the difference in treatment is related to gender. And then let us know if you'd like those links for equal access rules too. I think I neglected to put in the 2016 equal access rule, which applies to emergency shelters and similar programs. So we can provide you with that. Sorry about that.
Yeah, thanks, Liz. So what type of housing is covered by fair housing law? It's really everything and anything that is considered housing or a dwelling. And there are definitions within the Fair Housing Act which define dwelling. But these are just some examples and common ones that we hear about and experience in housing, apartment complexes, subsidized housing, condo associations, and homeowners associations are covered, cooperatives, lending institutions. So any type of thing that touches housing is generally covered by fair housing law. Just a rule of thumb there. So going further into familial status, familial status was an amendment that of 1988. It expanded the original protected classes and it strengthened enforcement mechanisms as well. So this amendment not only added familial status protections, but it also helped with enforcement. And it made it illegal to discriminate against families with children. It also added people with disabilities, both mental and physical. So with that amendment, we got those 2 additional protected classes. This is the kind of language that is found in there. So it means 1 or more people who either live with a parent or person having legal custody or are the designee of such parent or person having such custody with written permission and things like that. So what does that look like? Kind of some more simple terms here. Family is really broad. It is includes single people, pregnant people, people in the process of adopting or securing legal custody, foster children, grandfamilies, so grandparents raising grandchildren. Some other ones would be maybe siblings raising siblings. Different types of family dynamics. If there are children in the household under the age of 18, generally fair housing, you have the protection.
It's really amazing in 1988 that they had such a broad definition of family because it certainly has changed in the years since the law passed. To have all sorts of families covered is great.
Yeah. So some signs of discrimination. So what does this look like for families with children? It could be some advertising that kind of implies that children or teenagers are unwelcomed or unwanted. And we'll kind of go into some examples. So I'll just briefly read through these. We really wanted you just to have these as signs. Maybe stating it isn't available after learning that there's children. It could be charging additional fees because of the presence of children or charging per bedroom or refusal to rent. So those are kind of the basic things. We see some maybe a little bit more nuanced or a little more targeted would be families not having access to their recreational facilities, unreasonable rules, not allowing children to use certain amenities like the pool or clubhouse that adults are allowed to use, having adult time in different amenities, and then having a curfew or quiet hours that apply to only children and teenagers outside of local laws, curfews and things like that.
Yeah, so properties can have policies about quiet hours and things like that, but it becomes a fair housing issue when any particular group is singled out, like Bree said. If these policies are written or interpreted only against families with children, because sometimes the policy is neutral, but the managers on site, for example, might really only apply them or hold families with children accountable to them. So anytime it's singled out specifically or applied specifically to families with children or any of the other protected classes, that kind of brings it back under fair housing.
Yeah. Some more signs. Again, like kind of Liz just talked to, just having different standards, and then maybe standards even going a little bit further based on ages, restricting certain families to certain areas of a complex or a neighborhood or a floor. We often call this steering. So again, if the choice is being removed from the family, they're being restricted on anything, then that would have some fair housing risk, and that would be something that you could call us about. Talking about going back to our true and false, forbidding children of different genders from sharing a bedroom, or placing a limit on the number of children in general within the home. So moving on to what this looks like, occupancy standards. So this is something that kind of we can see be used as occupancy standards can be something a way people have used to restrict families with children living in their communities or in their neighborhoods. So that we're going to kind of go through what that looks like. So we're going to first do another poll to get everyone thinking about this. And let me launch that really quick. So is this a fair housing issue? There's two here. The first one, I am looking for 4 mature. So these are ads or comments that we have heard. I'm looking for a 4-bedroom or 4 mature and responsible people to share a 6-bedroom, 3.5 bath, 4,000 square foot, beautiful historic home. Is that a fair housing issue? Yes or no? And then the second one, 2 people per bedroom is our corporate policy, no exceptions. Yes or no to being a fair housing issue. So give folks about 30 seconds or so, to probably a little bit more since there's 2 questions there.
Yeah, and while folks are reviewing those statements for fair housing risk, I also just want to say, in case it's a new term for you, occupancy standards is a term we use a lot, but I'm realizing not everyone else might know that. So I just wanted to share that what we mean by that is how many people can reside in a home, apartment, any sort of dwelling together. So that's considered and called an occupancy standard. It's something that is often dictated by local property law or code at the municipal level. But just want to explain what that phrase is.
Give about 10 more seconds here. See the numbers slowly trickling up. Don't want to cut anyone off. All right. End that poll and share what everyone said. So it was pretty split on that first question. Looking at that statement, they're looking for 4 mature and responsible people to share a 6-bedroom home. So we would have some issue with this. There would be some fair housing risk there. One, we always talk about the property, not the people. So it is a best practice not to say how many people can reside in a home. And that it really should be based on the bedrooms. So that also is a really low number compared to the number of bedrooms. So only 4 people for a 6-bedroom home, that would have there would be some issues there. Also calling out what type of people they want: mature and responsible people. That can that just has some risk in language, because mature could be that no families with children would be allowed. And then the second one, 2 people per bedroom is our corporate policy, no exceptions. There is a fair housing risk there. And we'll talk about that kind of statement. That is a common thing that we hear. So it is for those that said, no, it's not an issue. It may be because you haven't heard of that 2 people per bedroom is not really the standard anymore. So we'll talk more about that through this next portion. Some restrictive statements that we have heard that are illegal statements. Parents have to have their own bedroom. Boys and girls cannot share a bedroom by law. So that going back to that first one, 2 heartbeats per room is Michigan law. That has not been shown to. There is no Michigan law that says that. Same with the sharing of a bedroom. If you have a baby, you have to move to a bigger unit. And we'll talk about a case, or no, we'll have a what would you do um, uh, poll in a little bit about having a child, but generally it has until the child's second birthday, until you can, if the unit is no longer the occupancy size, if you have the baby changes. So you have until this child's second birthday to find a bigger unit if that is the case. um, no more than 3 persons shall permanently occupy or reside in a 2-bedroom unit. No more than 4, which has been expanded to include a 3rd bedroom without the express prior written approval of the association. So this was something in a condo bylaws that we had seen before. So for occupancy standards, there is a reasonable limit based on local health and safety codes. But as we talked about in that poll that we did, it's really best to keep such limits out of advertising, just because it again it just has some risk there, because it could show that you're trying to limit um, families with children and things like that, out of your housing. It really, the reasonable occupancy requirements are really based on the number and size of bedrooms or sleeping areas, the overall size of the unit, any limitations or structure of the housing, um, age of children with caution, as we talked about. Sometimes there are exceptions there with having a new baby and things like that. So there are reasonable things based on local and safety codes. So, but it should be based on these things, especially the size of the area and the unit. Um, so we had a case previously where a rental company alleged that they had no more than 2 people per bedroom in each apartment or townhome. So that's really important to think. Apartments and townhomes are very different in size. Regardless of, and they said in their policy, said regardless of the square footage. If this was enforced, the policy without regard to local health and property maintenance codes that the state of the sorry, ugh, that state the square footage required for each occupant. So they didn't enforce this policy with any looking at the property maintenance codes and assessing if this was accurate based on the size of the units. In each of the 20 properties. This case was filed in addition with other fair housing centers. The company was found to have denied housing to families with children, again, despite the square footage for the family to be allowed by local codes. And not only were they prohibited from living in a particular unit, they were many denied from the complex altogether. So that there was there was multi-layers of the denial here. And with that, there was able to get a settlement of $207,000. The policy was changed and staff was required to get training after this case was filed and completed. So we have another interactive question here. So what would you do in this situation, or what should be done, sorry, in this situation? So you're looking for housing for your family when you notice, oh, this is the wrong one. I am so sorry. That's another one that we will do.
So Zoom is changing up all of our quiz option features, and it's been really challenging to navigate.
Yeah, they're not
There
in
we go.
order.
Good job. That's so tricky.
Sorry about that. So what should be done in this scenario? A family of 4 lives on the property in a 2-bedroom unit. They recently had a baby, which would be their 3rd child. It would be a now family of 5. The unit is 949 square feet and holds up to 4 people according to local code. But however, their lease is not up soon. Sorry about that. The answer is kind of cut off there. But so for the first one is begin the paperwork to make them move out. If they do not ask for a larger unit, they should not be forced to relocate. That third one, it's reasonable to give the family up until at least the end of their lease or the child's second birthday to vacate the premises. And then consult local ordinances, the Fair Housing Center West Michigan's fact sheet or guidebook, which will also provide those resources after this question. I kind of gave this one away when I talked about the comment earlier, but hopefully you were listening. All right, I'll give about 10 more seconds here to get in your answers. It is multiple choice, or it should be. All right. So the majority of you did pick the reasonable options. Again, give them at least till the end of their lease or until the child's second birthday. You can also consult our information for that. So again, if this were to happen to any clients you serve, or if you're a housing provider and this happens, it's really important that you give them that flexibility, especially as they're bringing home a new child, to allow them to figure out what the new phase of their life looks like and what that means for their housing. Um, and then if they do not ask for a larger unit, they should not be forced to relocate. That is a big one there. Again, allowing them to have choice is really important.
And essentially time too. There's been
Yeah.
a number of specifically condo association policies come to mind that families have been greeted literally by condo representatives, board members, property managers as they're getting out of the car, coming home from the hospital with the new child. And they've been asked, when are you going to quote unquote cure the violation of having had, a new family member? So it can be very, very problematic. So it's a good idea to pause and do some investigation and evaluation, kind of similar to the question that was just in the Q&A. We really want to do a individualized assessment, a case-by-case assessment to figure out exactly how many people can be somewhere, and then establish, what kind of breathing room is there, as Bree has shared with this example.
And a way that folks can determine occupancy, we do have a guidebook that walks through how that is done. It does have a step-by-step. We have only the current, well, at the time in 2019, the local units of government in Kent County outlined what their occupancy rules and regulations are, what they utilize in there. However, since this is subject to change, we always recommend looking for your current locality, what occupancy limits or property maintenance codes they have currently. Oftentimes it will defer to the International Property Maintenance Code, which I will is in a few more slides. But when determining occupancy standards, we'll kind of go through the steps here. So first, like I talked about, determine which local unit of government is covered by the property. And then if they have a property maintenance code or other code limiting occupancy, there are some resources to utilize, Unicode, AM Legal, or you can call your local government office to see. Step 3 would be to review requirements of the codes. And then
Bree, can we go back to the step 1 real quick? I just want to highlight, because this is something that I learned and was kind of surprised by myself, that you can have, for example, a Grand Rapids mailing address, but you can be actually located within the township of Grand Rapids. There's Comstock Park is another example. So it's really important to determine legally which unit of government covers the property, so that you can do the research and figure out the right set of property maintenance code or rules to follow. So I just want to highlight that, you'll see a lot of Grand Rapids addresses that are actually governed by other entities. So that's something that you really want to start as a basic step of, like, which laws am I following, to make sure that you're following the right set of laws. So
that's funny that you bring that up, Liz, because I have a friend mailing something to me and I sent my address and I have a Kentwood address, but it kept recommending in the shipping
Oh,
that it was Grand
suggested.
Rapids. It was Grand Rapids. And she was like, "Is that fine?" And I was like, "If that's what it's recommending, then I
Yeah, we'll
guess
see, right? In
we'll
about
see."
3 to 5 days. Yeah, so that's exactly it. And of course, automated forms, technology, those autofill things can add a layer of confusion. So this is a really important part of doing the homework. If you've heard us train before, and I see a lot of familiar names on here, so thank you for joining us today. This is an important part of doing that homework.
Yeah. Step 4 moves on to calculating that square footage of the relevant rooms. We do have a square footage calculator that kind of does some of that math for you with the International Property Maintenance Code numbers in there, and that's kind of you. That's a guide, but it can help you understand what that math looks like, and then use that information and to determine the appropriate number of occupants, and then document. So it's really important that if you do have a family or people that, you know, want to apply to a home and there is a limit and they are over that limit, then you have that to fall back on. You have that, you've done the math, you've done the work to show that, based on health and safety codes, that this is not, uh, this does not fit this number of people.
Yeah,
Or
it's
if
really
you are
about
an app,
checking. Go ahead.
or if you're an advocate, having that information, if you're working with a family, having that information from the housing provider, and knowing that they've done the work.
Mhm. It's about striking a balance. We don't want overcrowding, but we also don't want families. We had a question about housing for a family of 8, for example, just today. So, striking a balance between keeping people safe so we don't have overcrowding or health issues, but allowing for the appropriate number of people to live somewhere is an incredibly important option for families with children in order to have the housing they need.
Yeah. So this is what this calculator tool looks like, and then it is linked there for folks that have the handout. And then this is what I keep referring to, the International Property Maintenance Code. So this is the 2021. There should be another one put out this year. They're about every 3 years. So it kind of identifies what type of space, and then the square footage for the range of people. So for a living room, about 120 square feet for 1 to 2, and 3 to 5. And then 6 plus is 150. And then dining room and then bedrooms. For bedrooms, about 50 square feet per occupant. However, there's a minimum for 70 square feet for a 1 bedroom or a
Yeah.
bedroom for 1 occupant.
Yeah, so we had a question from someone asking about, is there kind of a general rule of thumb? So that may be a helpful starting point if you're thinking, gosh, that bedroom looks a lot larger to me, or my family that I'm advocating for said, there were 2 really large rooms and we're hearing a lower number than we think might be appropriate. So that's a good frame of reference to kind of say, all right, we need at least 50 square feet for multiple occupants, a minimum for one. So that's a starting point.
Yeah. And again, local townships may have different
Standards, yeah.
occupancy standards. This is kind of the broader one, if there is no standards, and often local ones also kind of abide by this as well. So we're going to look at an example of what this looks like of calculating. We're going to do some math this morning. So the first bedroom is 12 by 10. The second bedroom is 13 by 12. And then we have a dining room that is 9 by 10 and a living room that is 12 by 16 with this little layout here. So what does this mean per space? So the first bedroom can fit 2 people. It's 120 square feet. The second bedroom is 156 square feet, so there is 3 people allowed in that bedroom. The dining room can fit between 3 to 5 people, and the living room can fit 6 or more. So with finding that, the determination is 5 occupants because that is the number allowed per the sleeping space. Even though the living room is large enough to accommodate 6 or more, there's again only enough sleeping area for 5. And so that is kind of where the limit is put.
Yeah. And those living room and dining room spaces aren't intended for people to sleep in there. And there's not actually going to be 6 people sleeping in the living room. So I want to make sure we're clear on that. It's just kind of going back to that orange chart. it's kind of a way of kind of progressing along the different measurements to find out what the limits may be. If there were a very small living room, for example, that would maybe bump it back down away from 5 occupants. So this demonstrates the importance of having the unique measurements of the specific space that you're either looking to lease out or looking to move into, depending on, you know, which side of the housing transaction that you're on.
And then just really important, it's really important for people to be familiar with their occupancy standards within their local areas of government. For housing providers, especially, they really, if you're hearing more information needed, but housing providers really only need the number of people that will occupy the unit, the total number of people in the unit. If you're hearing from people that you're advocating for or clients that you're working with, they're requiring a little bit more information than is especially about children and things like that, like we talked about their gender, where they're sleeping, things like that. Where are people sleeping in the unit? That is just a little bit more information than is needed, and that would be something that we would want to look into if you're hearing those types of things. They really, occupancy policies really should not be more restrictive than any local standards. And then additionally, there is the Keating memo, which kind of outlines some of these things that we're talking about, and that can be found on our resources page on our website. So before we move on to advertising and I turn it over to Liz, we have one thing to get you thinking about advertising. So this is who do you call if you see an ad like this? So who do you call if you see an ad saying you're looking for housing and you notice it says phrases perfect for couples and no playground? So we have the United Way, 211, Legal Aid, city or county government, the Urban League, or any local tenants' rights organizations, the Fair Housing Center, a Fair Housing Center, and disability advocates. Give about 15 more seconds. All right. And the poll there. Most people put 98% of you put the Fair Housing Center of West Michigan, which would be the appropriate place to call your local Fair Housing Center, because I know we have some people across the state here. So yes, there is some fair housing risk here. Again, identifying the type of people. So as I mentioned before, it's really important that advertising doesn't have describing the people. It should describe the property. So if you see advertisements with your family or people that you're working with, and it has language like this, definitely call our office. And then the no playground, again, that it doesn't seem that it would be on the face super discriminatory, but again, it's deterring people from living in that space because there's no playground. They're calling out, oh, well, children wouldn't like it here. But again, that is removing choice, and that would be up to the family's decision to decide if they want to live there with no playground.
And we do offer to review advertising, so feel free to use this as a resource. However, before we fully leave occupancy standards, Bree, we have a couple of good questions in the Q&A.
Yeah.
I'll tackle the first one here, which is an exciting one and a very timely one. I think this is a really cutting edge area where people are exploring tiny homes and other types of what they call missing middle housing, accessory dwelling units, and all different housing options to really increase the housing stock, since we have a severe nationwide housing shortage that has really also hit Michigan very hard. So I do know tiny homes are legal in Michigan. There are some restrictions. They do have to follow state building code, and then they're kind of relying on local municipalities to then do an evaluation in terms of what their minimum square footage requirements would be and how it would be applied to the tiny home. So I think that is something that we may see more of. But generally, I haven't seen too many communities kind of keeping up with that at this time, but I know there's a lot of conversation going on. A lot of folks are looking at zoning reform to allow for more of these more creative housing solutions as well. So a really timely question that I think, we would have to look into the specific locations to see if there has been any changes to the local zoning code. I'm not familiar offhand of any, but that doesn't mean that they haven't passed already and I just haven't been able to keep up. So great question there. And then we have a family of 5 moving into a unit that only could hold a family of 4 as an example, with the youngest being just born. Could they move into that unit knowing they have to move out in 2 years? So that 2 years has really been established by case law. It's not a hard and fast rule. It's really a way of helping families who have housing kind of get that time, as we were talking about. I think we would want to be really careful in terms of setting a hard limit on that. In terms of, guaranteeing that they would have that time. It's really what's been established for people who have housing, so that they have the ability to either choose to move into bigger housing that meets their needs or have some time to adjust as a family and then move forward. It also is supposed to help. We'll share some cases about people who are expecting babies as well in terms of having a family growing. So yeah, I think it's a little bit more of looking on an accommodation, but I think it's one where we would really want to assess the floor plan and make sure there really was space. But I wouldn't want to use an expectation or have an expectation that they could have 2 years fully with that situation. So great question, Julia, and we're happy to kind of do a little more research into that for you. And then we have another question about how this applies when a leasing office requests that all adults be on the lease. Could this be a potential way to figure out who's in the house and what information do you need to provide in that situation? So we will talk about kind of the application process. But yes, it's very standard for housing providers to request applications from everyone in the household who's 18 and older, because they have the general practice of running credit and background checks and other kind of assessments related to income and household eligibility. It is definitely a way to figure out who is in the house. The question is, how is that information used? And is that information used to make a discriminatory decision? So it's really balancing that line of what do we need to fully assess the eligibility of the applicants versus are we gathering too much information that could put us in fair housing risk? Or is not a best practice. So really good questions. Feel free to keep using the Q&A feature. We really tried to save a lot of time for questions during this training because we know, there's gray area here, which does create sometimes some confusion and again, requires a lot of that individual house by house, layout by layout assessment. So I think there may be a question in the chat as well. About consideration for people who are looking to run a business out of a home, and it's a source of their income. Can they get a bigger housing option for an office or childcare? So that wouldn't be a protection because you're asking if the business would be protected, I believe. And if I've misunderstood that, let me know. But what the fair housing laws protect and really focus on are the rights of people. So the question of whether you could run a business out of the residence would be something that would have to be verified with lease policy and anything that's in any of the contracts related to housing. Some communities do prohibit home-based businesses, but there's not a right to have that included in the housing. Okay, advertising, kind of circling back here. It's all about messaging and communication. The original Fair Housing Act, which was passed in 1968, included, again, very foresightful language and an incredible understanding of what advertising could look like in the future. They didn't know the internet was coming in 1968, but the laws are interpreted to cover all communications, which would include verbal, oral communication, online communication, social media, good old-fashioned print advertising in newspapers and, flyers circulations, all sorts of methodologies that are essentially covered here, where they say you really can't state or publish or print any sort of language, whether you're talking about sale or rental, that has any preference, limits, or discriminates based on now any of the protected classes. Back in 1968, we only had 4 protections for race, skin color, religion, and national origin. Of course, the list has grown. So it's illegal to communicate any sort of preference, limit, or discrimination in the housing itself. So here we have a whole slew of examples. I think you can just kind of go ahead and pop them all up on the screen. These are all kind of ripped from the headlines, ripped from the actual ads over the years, where as you kind of scan these very brief statements, they violate fair housing laws over and over because they're really anti-families with children. Their preference language is very clear. When you say great for, ideal for, perfect for, plenty of room for, or flat out saying prefer, that violates that section of the law that we just looked at, where we're really seeing, no families with children being welcomed here or included, or we're seeing illegal age limits, 21 and older, 45 and older, 50 and older. None of those are legal here in Michigan because we have age protections. The only legal age restrictions you can have is 55 and older and 60 and older, and you have to comply with the Housing for Older Persons Act, or HOPA for short, which is basically that it's housing that is intended to operate and house older adults and serve older adults. And then we skip forward here to further ads and statement. Sorry, there's only a handful on that slide that are more punitive, really penalizing people for having families or setting limits. Our first one you can see is they're wanting no more than 3 minor children in a home. The second one, we're calculating rent on a per person basis and then applying fees for additional occupants, which generally is going to punish people who get married or have families with children added to their household. The third one, setting a maximum here for 1 or 2 people with 2 children only allowed, or our last one limiting 2 adults with up to 2 small children. So these sorts of preferences or limits were actually published and violate fair housing advertising standards and often invite investigations. And when these sorts of things are published, quite often the housing provider, landlord, or owner backs it up and has a policy, which is also illegal. So what do we do? And I think Bree, you might have mentioned this already. Describe the property. If you are operating a housing program, or if the housing is tied to supportive services included with the housing, you focus on the property, the amenities, you focus on the program, the services available, and not the people. So it's a real simple rule of thumb. If you're helping people search for housing, if you're seeing people targeted language or limits based on the certain perfect tenant, those potentially are fair housing violations. So we really only want to see descriptions of the property: 2 or 3 bedroom, large backyard, granite countertops, how many bathrooms, how many half baths, any upgrades, is there a new roof, all of those sorts of things that can help people decide if they're interested in that property without having a person preference, which automatically, as our list of protected classes grows, can discourage people. Simply stating a preference for one gender over another, you are automatically eliminating probably 50% of your audience. So there's good business to comply with fair housing, and also make sure that any communications that go around the housing opportunity are inclusive as well. So, social media has kind of become a go-to platform. Artificial intelligence, AI, learning machine software, all of this is kind of changing how we get our information. And we're very aware there's brand new guidance from HUD about how AI can be unfortunately used to discriminate, or is inherently discriminating because the people who program it, like algorithm creators, have bias. Generally, that's based on race, but Facebook and Meta have been sued for discriminatory ads. So we really encourage people, if you are publishing messaging, view it with your fair housing lens, and when in doubt, do not publish, do not post, do not send until you've done good fair housing due diligence, because people are desperately looking for housing. A lot of you on the call already know this, and looking for housing is really critical. And seeing something discriminatory, people might just move on. They're not going to spend time pushing back on that, and they may miss out on the perfect housing that meets their needs. So a lot of reasons to comply with advertising there. And getting back to kind of applications we had talked about as well, we've seen unlawful questions as part of the application process. So these are things that would be risks or red flags. We've had landlords asked to speak with daycare providers or kind of interview them about the children in the household. That is unacceptable. We've had landlords grill partners seeking to live together about why they're not married, lecture them. One particular case comes to mind. We had an 89-year-old engaged to a 91-year-old living in senior housing, and they wanted to move in together. And the housing provider did not want them to do that until they were married, which they were in the process of doing, but it takes time in their faith to go through that process. And there was a 2-bedroom available right away, so they wanted to snatch that up. Marital status is protected here in Michigan. We've had housing providers ask about the biological parentage of each child. Again, this is way more information than is appropriate to be requested. And our last one here is a real thing that happened in West Michigan, where an uninformed tenant was asked by a landlord to take a pregnancy test and bring it in with the application, which she did, not knowing that she did not have to do that. And unfortunately, didn't know her rights. And it was actually a property manager who reported this to us because she asked when she went to submit an application at the second place if they also wanted a pregnancy test. So, we really see people feeling entitled to a lot of information about the families, the relationships, that is unnecessary to evaluate their eligibility. So these are all red flags and risks. And this is information above and beyond what is necessary and should not be requested. So what information is necessary at what point? If you are a housing provider, you should only be collecting information relevant to objectively determining whether or not applicants qualify for the available housing. Do they have the matching credit score? Do they have good rental history? If you are doing criminal background checks, there's a whole slew of new guidance on that. So reach out to us or check our website for new guidance on that. For example, felony bans are being struck down as discriminatory now. So really focusing on, do they have enough income, the basics on eligibility, and really challenging yourself about asking additional information, especially if it's related to a protected class. On the advocate side, you can help identify questions that should not be answered. You can send that information to the Fair Housing Center. We can do some education and help advocate, to say this is information that can't be collected and shouldn't be part of making the housing decision. So especially because we see a lot of applications that have been used for years and haven't been updated. And so they're collecting information they're not even using, and it puts them at risk under fair housing. So really important to keep up with all of that and advocate to keep those unnecessary illegal questions off of the application standard. You can always collect information after the tenant has been accepted and moved in. If there is additional information about emergency contacts and things like that, but they really should be separated. Next slide, Bree. Here's a case out of Montana. This is a classic case of, unfortunately, both an owner and a property manager violating fair housing law. We had a family of 4 interested in a 3-bedroom, 2-bath duplex in a downtown neighborhood. It's near a university where the parent worked, and one of the daughters was attending school. The owner had set an illegal occupancy standard of no more than 3 people. She was saying she was doing it to protect the basement tenant from noise, but it was an illegal occupancy standard. With 3 bedrooms, you potentially could have 6 to 8 people in that space. The property manager was complicit in this and communicated that limit, and also told the applicant the owner was concerned about your daughters being home alone, or do you work from home? So kind of invasive questions about the family. These were older children who, as I said, one was already in college. So collecting additional information that's not necessary, and then just sharing her preferences, looking for 2 people, a couple maybe with 1 child, something like that. She's picky, she put money into it. So all these objections and kind of defenses that turned out to be evidence in the case. They offered and steered the family to a suburban mobile home that was nowhere near where they wanted to be and not at all what they were interested in. In the interim, they rented the duplex to a couple without kids, which contributed to the settlement. This was a HUD complaint. They alleged actual damages, including emotional distress, loss of the housing opportunity, inconvenience, and economic loss. And then I think we have one more section here to kind of look at very quickly, policies. Oh, lots of what not to do here. We've had housing providers just develop a bias. Oh, I rented to a family with teenage boys and it didn't work out, so I just don't deal with kids anymore. That's illegal. A manager telling a pregnant tenant and her caseworker because the manager knew the tenant was on disability income, that if she didn't keep the baby, she could stay and keep her housing, which is a clear violation. So again, kind of that overstepping and inappropriate. Mortgage lender, we see policies where it's just flat out written. This was a policy in condominium bylaws that separated people based on the age of children very clearly, 16 and over here, 12 and under over here. So very easy to prove that discrimination exists when it's written. Doubling the security deposit. This was bad advice given to an out-of-state landlord. It's illegal under tenant landlord law and fair housing law to do this. We have also seen evictions, so kind of punishing families. An owner didn't want pregnant women in the home, so evicted them because they didn't want babies in the home. So that's two parties who violated law, the property manager and the owner. We also had a student housing company. Once they learned that a young student had a child, they forced her to obtain a separate lease for the 2-year-old, which of course a 2-year-old couldn't sign, and pay double the rent. So that was a case that was brought that resulted in over $200,000 settlement in multiple states.
And Liz, we actually do have a question on student housing.
Mhm.
So this might be a great time to bring this up. Somebody had a question about off-campus housing, specifically in the Grand Valley area here in West Michigan, that they always almost say one person per bedroom. And so they're curious if that would have some fair
There's
housing.
potential for risk there. I mean, we need to look at bedroom size and overall layout and size of the housing itself, but that's traditionally something where they wouldn't be welcoming to a student with a young child, and that I think would potentially be problematic or bring some risk. So we would definitely need more information, and generally that's going to be the response. For us to be able to assess risk accurately, we've got to do the homework we're telling you that needs to be done too. We've got to know the layout, look at the measurements, look at the policies, check for any exemptions, of which there are very few, but they do exist. So this was a case that made national headlines. This was a property demanding an ultrasound and a letter from the doctor in order for a resident to renew her lease. So again, $270,000 settlement, training, and new policies. But 3 families, once the story went public, came forward with additional similar circumstances where they were kind of being forced to prove pregnancy, provide personal health information, all of which was a clear violation of fair housing laws. So we have a series of best practices here. Generally, we've covered them. So I think we'll just, make sure to have those of you who are housing providers to review these and make sure you're upholding housing choice, communicating, and doing that homework. I want to make sure we have a couple minutes here. I think there's a couple more questions, but highlighting that we have tons of information on all sorts of topics. You all received family status specific information, but feel free to use these links or reach out to any of us on the EO team here with specific questions. And with that, I think I will just quickly remind you that we can accept complaints of discrimination. We can advocate on behalf of clients if they give us permission. It's very important for these things to be brought to our attention so that we can hopefully get the policies changed and stop the discriminatory limits from happening.
Yeah, and Liz will talk about the statute limitations, but I want to say that even if the people don't fall into these timelines, that it's still important to report it to us to make sure it's not continuing to happen.
Yeah, so there's different windows of time to bring fair housing complaints forward. So please feel free to contact us. We will do the assessment and educate you about which laws might be coming into play. But the longest window is up to 3 years here in the state of Michigan, where complaints can be filed in the courts. There's administrative complaints that can be 6 months or a year. We have cooperating attorneys. We can help with mediation. If education is supported by the client, we'll reach out and try to educate the housing provider. Again, with the housing shortage, sometimes that education is critical to getting the application and the process back on track. People should not be retaliated against for exercising their fair housing complaints either. I see a really interesting question on, what about families and children living in properties when it's not built very well, or there's circumstances where the property damages easily, the management blames it on the children. That really should be scrutinized from a fair housing perspective. They can assess families for damages, any tenant for damages, but it does need to be, applied equally across the board. If families are being charged more treated differently, that's something that potentially could be evaluated through an investigation. So that's certainly something they need to know in terms of what their rights are. We've had housing providers provide less quality maintenance to families with children, or just simply ignore repairs made by families with children, which is a fair housing issue. And yeah, and a good question about, is there a fine line between telling someone that they're moving into a duplex that's shared with college kids and saying no families? So there's a very small exemption that if the owner lives on one side, or the owner's immediate family members will live on one side of the duplex, they have a narrow exemption. But if both properties are equally available on the market, then it's, certainly something you do not want to say any sort of discouraging messaging to, because that could be the perfect opportunity for them. It could be affordable. It could be near daycare, work, hospital care, whatever they need. So while I understand the concern is maybe being able to live together, that's where policies on quiet hours and things like that are important and can help manage shared living. That's what a lot of this is about. So we would strongly discourage any messaging that would discourage any protected class from a housing opportunity as a fair housing risk. So great question. We do have a lot of good information coming up this summer and into the fall with tons of great programming, more free trainings. We're really thankful to MISHTA for allowing us to provide these on a regular basis and dive into some unique topics, as you can see here. Other questions?
We did have
missing
one
any?
question in the chat. If there is a house or apartment designed for people with disabilities and a family that is fully bodied, able to, and they apply for that house, can they be refused due to them not having a disability?
Yeah, so you don't have to hold apartments or units that have accessible features for people with disabilities. They don't have to be withheld from the market. People without disabilities aren't a protected class generally. So, I think there's kind of a little bit of a middle ground there. Anytime you withhold a housing opportunity, you really want to do an assessment of other risks beyond just that protected class. So feel free to reach out to us with the specifics. But accessible units and apartments do not have to be held for people with, the direct needs for those amenities.